education accountability. Can I have counsel for plaintiffs announce?
Good morning, Your Honor. Corey Langhofer for the plaintiffs.
And counsel for Mr. Fontes?
Good morning, Your Honor. Karen Hartman-Tejas on behalf of Secretary of State Adrian Fontes. And Secretary Fontes takes a nominal position in this matter.
Okay. And who do I have for Protect Education Accountability?
Good morning, Your Honor. Jim Barton of Barton Mendez Soto here on behalf of the Protect Education Accountability Now Committee, real party interest.
Okay, thank you. So, counsel, have you all spoken about the issues in this case?
Yes, Your Honor. I'll go first. Mr. Barton and Ms. Hartman and I have worked together on a number of cases, so have a kind of cadence for how we approach these things. This one is unusual for an election case. This is the most complicated type of election case that we've got in Arizona. We've got about 420,000 signatures on this measure, about 218,000 signatures that are at issue. There's about 46 legal issues, so this is a lot different than a candidate challenge. We've begun disclosures. There's many gigabytes of data that's been produced already, and probably have a few more on the way. And we've talked about whether we think tomorrow is realistic for a trial on this. I think we all agree that's not feasible given the complexity of the issues here. And we filed yesterday a request for appointment of a special master. I'm happy to talk to you about that. I don't know that Mr. Barton's had time to review that and take a view yet. We're probably going to need, if we have a special master, I think 2 trial days would be enough. If we don't have a special master, it may require 3 to 5, depending on how many stipulations we can work out with Mr. Barton. We've in the past been really successful narrowing the issues and avoiding witnesses where possible. But obviously, it's very fact intensive. And I think no one wants to consume more trial time than necessary, because many of the issues in these cases, like doesn't address match, for example, we can work that out between the lawyers. We don't need Your Honor's time. Logistically, there's an August 20th ballot printing deadline that's claimed by the state here. There is some indication last cycle from the Arizona Supreme Court that we may not need to comply with that deadline, but I don't think people are really anxious to sort of test those limits. So in our view, we probably need a final judgment by about August 13th, a week beforehand, so we could, whoever wishes to, can go up to the Arizona Supreme Court. I've got some logistical questions about exhibits, but I think for now, that's kind of the lay of the land.
Okay. So let's circle back and touch on a few of those points. It seems to me that some of the issues that are raised in the complaint should be solvable by the parties. For instance, whether or not a signature gatherer was registered. It seems to me that's a fairly easy issue that the parties could agree upon. Is that a fair assumption?
I think that's exactly right, Judge. And so what we've done in the past is, since we have the burden of proof, we prepare an exhibit for every one of the objections and disclose it to the other side and say, here's the reason, here's the signatures we think are at issue, and here's the reasons why we think we're right on this. Sometimes then the defense will go through it on their own and get back to us with the ones they think are wrong. Sometimes it's more efficient to sit down with a special master and kind of go through them together. If it's a little bit more interactive, or we're kind of trying to agree on which line to draw. But I think in principle, Your Honor is right, that it would not be a good use of your time to sit and watch us as we work those things out, because usually we can come to terms.
Okay, Mr. Barton.
Yes, Your Honor, I agree. A couple of things. I do agree. Our goal should be to have a decision by the 20th of August. By the Supreme Court. And I think giving the Supreme Court a week to hear it is the quote least we could do, if you will. So I think the 13th is a good target date for a final decision. I also agree that the special master proceeding has been sort of a device that we've used in these the last several that have had this kind of challenge, and I think it makes more sense, because I do think it made sense to do that. we can agree, it's easy enough to agree that if a notary stamp is missing, that the sheet is invalid. It's not always as obvious as you might think whether there's a notary stamp there or not. So I think having the opportunity to do what Mr. Langhofer is talking about makes a lot of sense in front of a special master where we can sort of work through things. I do think we're going to raise some challenges to the issues too, including something that's fairly the application of strict compliance and whether in this particular context as applied it unfairly burdens the right to initiative, etc. So I do think it makes sense to have a motions day and probably a special master's hearing, and then I do agree that probably 3-day trial is we can probably do it in 2 or 3 days. I think especially with a special master, maybe have 3 days to be on the safe side. I don't think we're probably going to be prepared to do anything tomorrow at 9 a.m. To be honest.
Okay. And Mr. Barton, when you were discussing motions, were you thinking those would be posed to the special master or to me or some to each?
I was thinking to you, Your Honor. My
Okay.
experience has been the special master just makes factual findings.
Okay. Okay. And the motion day, would that be included within the 2 to 3 days of trial, or would that be separate?
In my remarks just now, I was thinking it would be separate, but you know what? We probably could include it, and actually, we probably could do 2 to 3 days. If we have 3 days, and we just kind of in our heads acknowledge that one of those days, or at least half of it, is going to be legal briefing, a motion practice type argument, then that probably is still fine. I think we could still get it done.
Okay. And Ms. Hartman, do you have anything you'd like to add to what we've discussed so far?
No, Your Honor.
Okay. Okay. Have you all discussed a special master? Do you have anyone in mind? Have you checked to see if there's someone available on your short time frame?
That's
Mr.
always the
Langhofer.
trouble. We've discussed it only conceptually. In last time Mr. Barton and I had a case together, we couldn't agree, so we submitted 4 names to Judge, I think it was Tomlinson, and he picked one. I'm pretty flexible on this. We're asking judges to decide, or special masters to decide whether a date's missing, and I don't view there as being a significant difference between options here. So perhaps Mr. Barton and I could confer and get back to you by noon or something like that.
Okay. Yeah, and check and see if that individual's actually available on your time frame. Okay.
If we're checking with them, it may be end of day, because if fast as prologue, it takes a little bit to hear back from these candidates and for them to decide whether they really want to take this on.
Okay. 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 We'll talk about trial days in a minute, but Mr. Langhofer, Mr. Barton, do you anticipate issuing subpoenas for attendance of any of these signature gatherers for the hearing? And if so, how many?
Yeah, this is, we do anticipate issuing some subpoenas. This is always quite an issue to tackle. So I'll give some background on this. Years ago, there were, I think, 2 different cases where the plaintiffs took the strategy of subpoenaing every or virtually every circulator. We don't, and then the Supreme Court's frowned on that, understandably, and it's been a real burden for the trial court too. What we have done is taken the list of all of the objections that we've interposed that require some information from the circulator. Like there's a real question about where they live, for example, and whether the residential address they gave was an Airbnb that was rented for a week or something more than that. So you kind of have to talk to the circulator about that. So that list is not short. I think the first cut's around 100 names, but we've written to Mr. Barton yesterday a long proposal for how we cut that down to something that's very manageable. So our view is, first of all, any witness who wants to appear remotely should be allowed to do that. Any witness who's not available on the trial day will work to do a sort of virtual deposition in lieu of trial. There's also some stipulations. This is probably the most effective part of it. There's some stipulations we can reach that will make that it's just unnecessary to talk to these circulars. So for example, there's 34 of them who worked for a particular signature gathering firm. We've got reason to believe that they were paid per signature, which means, that would be a legal problem. Rather than talking to 34 circulators about that, we would just want to get some stipulations about what the payment arrangements were at that firm. So we could talk to the, one or two people running that firm, work out those facts, and then get rid of 34 circular subpoenas. So for all but one of the circulators, there's a way that we can avoid calling them in and burdening them and the court. So that's the sort of the magic of making this trial bite size, is like working that list down to stipulations that obviate the need to talk to people.
Okay. And the reason I asked about subpoenas is beyond just the amount of time that it would take in trial, but the burden that imposes on the clerk's office and needing to make arrangements in advance to get all of those issued for you all. So the sooner you can let me know the number of subpoenas, the sooner I'm able to coordinate with the clerk's office to make sure that we can get all of that issued for you in a timely manner. Okay.
I appreciate that. In the past, Mr. Barton and I have agreed to postpone the issuance until we kind of know what that number is. But
right.
I don't know whether he or the court would prefer if we just issue all the potential candidates now and then withdraw them later in light of stipulations. So we're ready to schedule something with the clerk now, but that's kind of burdensome for everyone and expensive. So I'm happy to put it off too, if that's better for parties.
Yeah, maybe if we can get it narrowed down a bit and then come in and have them issued, even if you decide later that there's some that you don't need to actually have appear, that would be fine. But issuing 100 subpoenas is expensive and burdensome. And so let's try to avoid that if we can narrow that down to, say, 30 before we undertake that process.
Yes, understood.
Okay. Is that doable, Mr. Barton, Mr. Langhofer?
Yes.
I mean, yeah, if you have an objection, let me know. So, okay.
That's a good proposal, Judge. Thank you.
Okay, so trial dates. You're thinking the second week of August?
Yes. So if the goal is to get a judgment by the 13th, the 10th would probably be about the latest we could start. Now there is a wrinkle here I should put on Your Honor's radar. Usually what happens is the trial court will say, okay, objection 1A is sustained, objection 1B is denied, objection 1C is sustained. You sort of say yes or no to the categories. And then once that's done, that's kind of the legal principle. There's a math problem of figuring out, okay, how do we eliminate all the ones that have been sustained, the objections have been sustained, but not have redundant invalidations. That takes about, a few hours of the parties working together to agree on what the number is. So unlike a normal case where Your Honor could finish the trial and then say who, whether it's on the ballot or not, here there would be some interaction between the parties. It's possible for Your Honor to issue a 54B judgment with just the rulings on the categories to start the appeal. And then we could work out the math later. But I just want to flag, usually the math question of implementing Your Honor's rulings is not something that the court has taken on. And we really wouldn't expect it. It's kind of a technical problem.
Okay. Mr. Barton, do you want to weigh in?
I agree on that, and we've all become more advanced in our technology as these cases have been litigated, and we have a dashboard, and I'm sure Mr. Langhofer has a dashboard, and I think we can. I do agree. It'd take a minute. I mean, it's not something that we could do, in real time necessarily. But my suspicion is after we have the rulings on which objections are upheld and which ones are denied, we could each put it into our own dashboard, if you will, and then say, well, this is what we think the number is, and and figure that out between the two parties easily enough, I think. But it would take, I mean, I think that's right. We need to think about allotting, some amount of time for that.
Okay.
I also think if that meant that the Supreme Court got it on Friday the 14th instead of August 13th, Thursday, August 13th, that's probably not the end of the world either.
That seems right.
What do you all think it's possible to start on the 7th? And then to address those issues and then give you the weekend to do your dashboards and then return on the 10th? Or do you think that doesn't give the special master enough time to address the factual issues?
I'll clear my calendar for this, so that'll be fine from my perspective. And if we're giving the special master a week and a half, that's doable. That's ambitious, but doable.
A week and a half?
We're
giving him a little over a week, or her a little over a week, right?
Yeah.
Assuming you could get everything to them tomorrow, right? It's like a week and a day. So
we will. I'm happy to. We can get them to disclosures, in 15 minutes, but they're already in a shared drive. The problem I anticipate here is that a special master would say, I'm interested in doing it, but I only have 2 days next week or 3 days next week, right? So if we keep searching until someone says, I've got, let's say 4 days next week, then I think that works fine. We'll see whether we, prevail in finding someone with that sort of availability.
Okay. Mr. Barton, your thoughts on starting the end of next week and then giving, so we can address those, the decisions you need from me before you start doing the math?
Yes, that's right. So in other words, I think we could start on the 7th. We could start doing and then have the 7th and the 10th for the trial work. And even if the special master's report, the special master's report doesn't necessarily have to be completely done when we start the hearing. I mean, it has to be mostly done so we can know what kinds of issues we need to bring to you. But I think it's perfectly reasonable. I think starting on the 7th makes sense, and knowing we'll do the 10th and then we have the 11th available if we need it. Like, I think a trial schedule like that is doable. And then, we may have to work in parallel at the very end there with some wrapping up with the special master and preparing for the trial or doing the trial at the same time. I think we can do that.
Okay. Well, my next 2 weeks are yours. So you tell me if the 7th and then continuing on the 10th and 11th works, or if it would be preferable to do the 10th, 11th, or 10th and then take a break for you all to do the math and the dashboards and then resume, say, on the 12th and 13th. You tell me what works best for you, and because, like I said, my next 2 weeks are yours.
My sense is the 7th, 10th, and 11th would be a good solution.
I agree.
Ms. Hartman, I've kind of kept you out of the loop for a bit. What do you
that's fine. I'm happy to be out of the loop. This is really my colleagues are the ones who will be doing the lion's share of the work. So I have no objections to the proposed procedure. I know in the past, the counsel for the secretary sort of has not always been there for every minute of the special master proceedings. And I think that we are comfortable with that so that we can, with a rather small team, handle this and the many, many other cases in which the secretary is a party right now. But this is all acceptable to the secretary.
Okay.
We would be fine excusing the secretary from the special master proceedings and trial, for that matter, if they so choose.
Yeah, I mean, we certainly intend to be there for trial. I'm sorry, Your Honor.
Yeah, I'm sorry. I'll let you all discuss the extent of the Secretary of State's participation offline, and you can tell me what you prefer. But so we don't put Mr. Barton, who's fairly new to this proceeding, on the spot here today. We'll let you discuss that offline. Okay. The court has no objection to any witnesses appearing virtually, particularly witnesses who are out of state. We will provide you with the link for those witnesses to appear. So let's talk about exhibits.
Yes, so we'll have quite a few exhibits. I expect most of them would be stipulated or certified. Some of these are really voluminous, like in the order of gigabytes, and so there'll be a problem uploading those to Case Center. Many of them are not so large, though, right? Some are just normally sized exhibits, and so I don't know whether Your Honor wants us to upload everything that we can in Case Center and provide a flash drive for the others, provide a flash drive for everything. Paper copies would be fine, but for the petition sheets, really, because the petition sheet's 40,000 pages, and we've never yet been required to print them. I hope this won't be the first time. So just looking for direction from the court on how you'd like us to handle that.
Okay. Mr. Barton?
Your Honor, I agree that almost all these exhibits, as far as admissibility, will stipulate to them. You know, I mean, we need to probably talk about it in a little bit more granularity, but yes. And I also, I have no preference on whether we do everything on a flash drive or whatever. I don't know if we're going to have any exhibits, but we might have some. But it's Mr. Langhofer's the one that has the big data issue.
Okay. The court's preference would be to upload what you can to Case Center and bring in a flash drive for those things that cannot be uploaded to Case Center. That makes it easier on the clerk's office for processing those exhibits, because they would only have to process those that come in physical form. When I was reviewing the complaint, I noticed that some of your exhibits attached to the complaint are very difficult to read, partially because you had to shrink them down to 8.5 by 11. But am I going to have that same issue at trial, or are they going to be in a form that can be manipulated and enlarged beyond what Case Center permits? Because Case Center's enlargement capability is relatively limited still.
Those spreadsheets, Exhibit A is terrible to deal with in PDF format. We'll be using Excel, okay, because it's so much easier to use.
Okay, great.
Well, I've got some tedious questions I won't bother you on.
Sure.
Perhaps I'll connect with your clerk, deputy clerk, and the clerk's office on some of those smaller questions.
You've got me. Let's
see.
Let's see if I can answer them.
The question, I guess, was whether you would want a separate flash drive for every exhibit that's too large, or one flash drive with all the exhibits that are too large. And then
answer to that depends on whether or not you stipulate to them. If you stipulate to them, they can all be on one flash drive. If there's going to be a dispute about admission, then those would have to be on a separate flash drive, because, you know, if I accept one flash drive and it has something on it that has not been admitted, then I can't accept it. So
that makes sense. And then with Case Center, there's this funny numbering problem. I think the first one you upload is numbered as Exhibit 1. So I think I should probably upload sort of placeholders to make sure for anything that will be on the flash drive. I think I should upload a placeholder that says, you know.
Yes.
Okay, and so that we don't have numbering issues. Thank you.
Right. And you can renumber in Case Center if necessary. So if you upload something as 1 and that really should be 3, you can renumber them. But you do need to put in placeholders for anything that you intend to submit in physical form during the trial.
Perfect.
Okay. Any other questions?
No, thank you for for bearing with me on those.
No problem. Okay. So we're set for the 7th, 10th, and 11th. What time would you like to begin those days?
9?
Okay. Yeah. Okay. Yeah, we were set for 8 o'clock tomorrow, but I don't feel free to start at 8 o'clock on my behalf.